with the charges, those files, so they should be available to you via the court system. Okay. Um, Otherwise,
Good morning, everyone. I'm Marty Jackley, South Dakota's Attorney General. Because everybody knows, on March 27th and into March 28th of this year, there was a disturbance at the penitentiary. That disturbance involved an assault on two correction officers. It involved the setting of fires, and it involved damage to taxpayer property. I had requested as Attorney General the state DCI to work with prison officials to investigate what had occurred and to work towards holding those responsible for the events on the 27th and the 28th. The DCI has completed that investigation, and I've had an opportunity to sit down and discuss our findings generally with the governor. At this time, this morning, I have moved forward in the signing and request for arrest warrants involving 11 individuals at the penitentiary, involving 18 felony counts. The most serious, of course, is the assault on our two correction officers. One individual, an inmate, has been charged with respect to the assault on two correction officers. There are two counts of aggravated assault. Those carry a significant 25-year maximum. And then again, because there are two correction officers, there are two charges of simple assault. It's a class 6 felony that carry 2 years. With respect to the fires that were started, there was the use of a inmate denim jacket, a pillow, bed sheets, towels. They were thrown on a wheelchair that started that on fire. And so there are 4 individuals that have been charged in relation to that. The more serious charge is the class 4 felony. That felony carries a 10-year maximum penalty for reckless burning. Those same inmates are also charged with basically it's starting a fire in a correction facility, which is a less serious offense. It's still a felony. And then finally, 6 inmates have been charged with felony damage to property. We valued that property at a value between $2,500 and $5,000. All this occurred at East Hall. They involved primarily one gate. There was 2 gates that the inmates tried to throw a locker through and damage that property, amongst other things. So at this point, it is my position as Attorney General, of course, these 11 inmates are presumed innocent, but this matter will be addressed to the fullest extent of the law. I believe strongly as Attorney General that the prison is a dangerous place, but it's where inmates go to better themselves, to follow the rules, and when they don't follow the rules, there will be significant consequences. I think we have to take that position as a state in order to protect our correction officers, and certainly would make myself available for any questions that you may have. Yes.
Why do you think it's taken nearly a month for the media to get a substantive update on these disturbances?
Yeah, part of it was because of the criminal investigation. I would tell you that when you're involved with sorting out events that occur essentially beginning the evening or the afternoon of March 27th into the 28th, there was significant interviews to happen. Our team interviewed correction officers, inmates. We had very good assistance from Department of Corrections, Special Investigation Units, and other correction officers. With that, of course, we narrowed it down to 11 individuals. There is significant footage. I will use an example with respect to the assault on the two officers. I had an opportunity to look at that assault. It's literally on 6 different pictures, areas of video. So there was significant video to go through with respect to the burning, the property damage. We wanted to make sure it's as thorough an investigation as could be, and that we gave the inmates an opportunity to be interviewed. Some accepted that, some didn't. And that's in part why it took this period of time. I would also tell you that we had to put together and move forward, not just with a complaint and arrest warrants, but with other process that is occurring. The affidavit of probable cause is now on file, and you can certainly have access to that, kind of laying out the investigation and what we found.
Can you speak to the extent of the injuries for the correctional officers?
I'm not going to go into detail, but I would say this. With respect to the charges, the aggravated assault involved really 2 forms of assault. One is generally described as a choking, and the other would be indifference to human life. Both of the officers were treated at Avera and released.
And were they put on leave?
That's a question for the Department of Corrections. John?
How many people didn't get charged? Are we to assume that these 11 are the only ones who were involved in the disturbance, or are there people who were involved that simply didn't commit crimes?
What I would say is this. At this juncture, I felt that there are 11 individuals with 18 appropriate charges. I felt strong enough to personally sign that complaint based upon a probable cause affidavit. And what a probable cause affidavit, I think, as you all know, is to demonstrate that there's a likelihood a crime was committed and these individuals committed it. They have an opportunity to have their due process and a trial on the merits. They're presumed innocent. Like with any case, when you've got 11 individuals and you have 18 charges, there may come opportunities that the inmates may be willing to proffer evidence, to turn over state's evidence. And so I would never say that these are the only charges stemming from it, but these are the charges at this point in the investigation through inmate interviews, correction interviews, videos, and other evidence that we felt there was probable cause to move forward.
But there were other inmates who were involved in the disturbance beyond these ones who've been charged.
I think that's fair. When you say involved, the involvement might not have been to the level of criminal activity. It may be to the level that the Department of Corrections handles it administratively. I feel strongly under the law, guilt by association isn't our law in the United States. That just because you're present doesn't necessarily mean that you have a criminal responsibility. It may mean that there's going to be administrative action or other consequences, but not one of criminal. Does anybody have any other questions?
To what degree did understaffing at the South Dakota State Penitentiary contribute to or exacerbate these disturbances?
That's certainly a Department of Corrections question. I will tell you from having watched the video that the correction officer that was attacked was punched, his hat flew off, fell to the ground, and immediately there was another correction officer there to help. So I don't attribute staffing with respect to the aggravated assault charge and the simple assault charge to have affected that. As far as the other matters, those are questions for the Department of Corrections. I would tell you that one of the guards that was assaulted was experienced and one was less experienced, which is what you would expect. That's what we typically in law enforcement purposes of training and otherwise. So that at least the assault side of it, I don't believe that staffing would have had any effect on what happened.
The guy who came in to help, was that the experienced officer?
The other way around. The other way around. I would tell you that there had been some previous issues, and you'll see that in the probable cause affidavit. And so that more senior guard took what I would deem as appropriate conduct, and he put himself in that position. And then obviously the less experienced guard quickly reacted. And again, I think my position as Attorney General is that inmate made a decision, and my job is to hold that inmate responsible for that decision.
Can you speak to where this all began? Did it begin with the assault on the officers? Did it begin with the fires? How did it all begin?
It began, of course, this is East Hall, and it began with the assault on the officers.
Okay. And then can you speak to like the legality of the staffing ratios at all? Or
Those would be Department of Corrections questions. I mean, my job as Attorney General is to frankly put people in the state penitentiary, and when they don't behave themselves in the state penitentiary, to address that. And that is part of today. I would tell you that the governor has been supportive. She was debriefed, and her and I are on the same page that these steps are important. They're significant in order to protect our correction officers.
Do one more.
Sure.
Can you tell me about your involvement, if any, in the investigation into the various activities surrounding the tablets? I know that I don't know that any of us made a direct line between one and the other, but it's sort of happening at the same time. As I understand it, there's something criminal there. Are you guys involved in that? And what can you tell us at this point?
With respect to the tablets, let me say up front that that's a decision for the Department of Corrections. When you see the affidavit of probable cause, you will see that the tablet issue, I think, instigated or began the disagreement between the guard and the inmate. And of course, you'll see in the probable cause affidavit that guard had nothing to do with whether or not there would be tablets or not. With respect to other investigations, certainly we are involved in investigations where the tablets have come up, but until any charges would be filed, I'm not at liberty to talk about criminal investigations.
Is it accurate then to say that the lack of tablet access was a catalyst to these disturbances?
Yes, with this understanding. My position as Attorney General is if a cable TV is not offered, or a tablet is not offered, or something of that nature, the appropriate remedy is not to beat up a guard. There'll be consequences for that, and part of those consequences are being shown today with 11 felony charges and 18 counts, which is 11 individuals under 18 felony charges, which is significant. But yeah, it's fair to state that when you see that probable cause affidavit, I think the inmate's frustration is what was at least his reasoning for why he took certain action, which is unacceptable under the law. And as my position as Attorney General, we're addressing it with these felony charges.
Are these charges consistent with other instances where a correctional officer is assaulted? Is it typically 2 aggravated assaults and 2 simple assaults?
I feel the answer is yes, given the nature of that. I would say this, that you will see sometimes, and you've seen it recently, where our office will charge attempted murder. We looked hard at attempted murder. That is not included in these charges at this point. It doesn't mean that amended charges won't come. But if you look at the way I, as Attorney General, have addressed these, that range, depending upon the significance of the assault, can be attempted murder or can be aggravated assault or simple assault. At this stage, based upon what we've seen on video, based upon the interviews that have been conducted, we made the determination, the charging decision, that the appropriate charge is aggravated assault, which is of a correction officer, which is in this instance a 25-year maximum felony. And there are 2 counts of that.
Is it too much to describe these disturbances as a riot?
Here's what I would say as Attorney General. I mean, you go back and look historically, I think it was in 1954, there was a riot situation. When I prosecuted the death penalty cases of Burgett and Robert, I think you maybe even in Portland heard me use the word Burgett was involved in the riots that Attorney General Barnett had to address. I mean, I'll just say the reason I've used the word disturbance, from our investigation, what I've reviewed, prison officials never lost control. That they had always maintained control in the assault, that there were 2 officers there immediately, and it was addressed. When you look at the property damage on the gates with the trying to throw the locker through, the inmates never took over control. The fires were from cell to cell, thrown on a wheelchair. And so because there was never a control lost, I've used the word disturbance. If you look back at the 17 escapes that Burgett tried, and you look back in 1954, or instances when I think it was Attorney General Barnett had to issue his memorandum on the condition of the prison. This didn't result in that. Certainly, local law enforcement was there, DCI was there, but we never had to go in because prison officials did not lose control. So I think that's why I use the word disturbance. You use whatever word you think fits it, but to me, a riot is when prison officials have lost control, and I credit it to those correction officers were there. They immediately took control of the situation, and it was addressed. And again, we've interviewed the witnesses that are available. We've looked at hours upon hours of footage, and we've made the determination of who we believe should be held responsible, and they are presumed innocent until proven guilty.
So we can get a better idea of how many people were involved on both sides. How many corrections officers or prison officials did it take to bring order back?
Really, it was the second officer brought order back when it came to the assaults. On the other, you've got inmates that are in their cells passing items on fire back and forth. Once the wheelchair was removed, that was brought back to order. Similarly with the gates, once the locker was, pushed through the gate or however you want to, characterize it, it was really brought under control. And so that's why there never was an instance where I had to ask all the state's DCI agents to go in and take control, because prison officials had control of the situation.
One more. I'm sorry to return to this topic, but I feel like, I know it's an open investigation, but I feel like I have to ask this. I've heard from a lot of family members, inmate family members, who feel like the decision to shut down the tablets for the various purposes or whatever, they feel like they're being punished for the actions of a few people, but we really don't know if it was a few people or if it was really widespread. Can you give us some sense of the scope? They're being forced to put their head down because somebody screwed up once. What's the scope there?
I think, from my position as Attorney General, the scope that I can talk about is criminal activity. And I'm limited under the rules until I file a document like I have today with requesting arrest warrants and affidavits of probable cause. It's really a question for the Department of Corrections. One of administrative nature, those were administrative actions that were taken. I'm not able to comment if, for instance, I were to bring a criminal act against an inmate. I can't comment about evidence. It wouldn't give that inmate a fair opportunity to be presumed innocent and to have his day in court. So I can't go into detail on the tablets other than those are administrative decisions by the Department of Corrections. They really don't affect my investigations because, again, whether or not that decision was appropriate or not, inmates can't assault correction officers. Inmates can't light things on fire. Inmates can't throw lockers through gates. That conduct will not be tolerated, and those that are responsible for that will be held responsible.
But would it be fair to say that you are not investigating hundreds upon hundreds of inmates for engaging in criminal acts using tablets prior to this?
That would be fair.
Okay.
Now, doesn't mean you might not see a report or a trial in the future where that comes up. And again, you're going to see an affidavit of probable cause that it sets out how this confrontation started, and it is a result of the tablet issue.
Thank you for your patience.
In the debriefing with the governor or just throughout this investigation, has there been anything gleaned as far as the contraband, as far as what's being shared as far as contraband inside the state pen?
I didn't go into those kind of details. What I would tell you is I had an opportunity to meet with the governor, and I expressed, number one, my appreciation that the correction officials worked well in our investigation. I think she needed to know that we were given access to whatever we asked for. We interviewed a lot of individuals. They gave us facilities so we didn't have to remove inmates to other locations and create dangerous issues. So I wanted her to know that. I also wanted to understand that we did take the investigation seriously and that we were going to move forward on, at that time we didn't know exactly the number of charges, but a significant number of charges, and that we would be moving forward on them this week. That was the gist of the conversation. And again, she has been supportive of, number one, the investigation, but number two, the concept that individuals that are harming guards are going to be held responsible to the fullest extent of the law, and that's what's happening here.
Marty, do you have to prosecute all these? How do you do all these separately, or can you do some of this as a group? You get 11 different hearings, 11 every time, or how's that work?
So it's a charging decision. So in this particular matter, you see that the complaint, they're listed all as one event. And so at this time, there will be one trial, 11 individuals, 18 counts. Under the law, I could have indicted, or could have asked for an indictment or filed a complaint on 11 different individuals, resulting in 11 trials. I chose not to do that. That doesn't mean that a defense lawyer won't file, we call it a motion for severance, which would allow them to state they can't get a fair trial altogether and that they would like to be treated separately. I would tell you up front, I would oppose that. I feel this is really an event. It started on the afternoon of March 27th and really continued on into March 28th. And therefore it's most appropriately charged together. And that's the position I've taken with the charging decision.
Can you tell us anything about Joshua David Warwick? His name is familiar to me, and I can go look him up.
Normally, it's not even appropriate for me to begin the subject of somebody's criminal history, but because this happened in the penitentiary, I'm at liberty to say that he's an inmate, and beyond that, I can't comment regarding the details of his past or his criminal history.
You said earlier in this news conference, the quote, "The prison is a dangerous place." Can you elaborate on that, please?
Certainly there are some individuals that are there that are doing their time. They're working to better themselves. They're picking up different skills. I mean, that's what Pheasant Industries does. But then there's other individuals that are not necessarily there for those same reasons. They have oftentimes a violent past. They have a history of that. We all know what recidivism means. And so there is a group of individuals that somewhere down the line, law enforcement and a prosecutor and a judge felt that society needed to be protected from them, and therefore they are placed there. And so that's why it is so important that there be administrative rules in place to protect everybody's safety. And it's not limited to just correction officers. It's medical staff, it's other inmates. And if you look at the charging cases from the Attorney General's office, oftentimes there's a lot of violent charges that come from there. We just finished the jury trial on the Mines case. That was about a 3.5-inch homemade knife situation on threats to correction officers. We've had other correction officer assaults. I think it's in part why the legislature has said when things happen in the penitentiary, there are enhancements. Typically, the assaults on law enforcement and correction officers, those are enhanced penalties. It is a dangerous place. But I think when there are rules put in place and there's an expectation that those rules are followed, it makes it a safer place. And that's part of what this charging decision is about.
You said one incident, it is, but there's really 3 stages here, right? I mean, there's the assault, that's one person. The intentional damage to property is just this locker incident, or are there other pieces of that relate to the inmates you were charged with that? And then there's the fires, right? They're all sort of separate micro incidents.
I break this down really into three events. There's the assault that involves 2 correction officers and 1 inmate. And then there's the fires. If you look how we've charged the fires, reckless burning is this. So there are 4 individuals charged with the fires. Reckless burning is the serious felony. It's a class 4 felony, which is a 10-year felony. And then the starting the fire in a correction facility is the same 4 individuals. It's the same event, and so it's like a charge in the alternative. And then there's the destruction of property. I would say that goes beyond just 1 gate. It's damage to a 2nd gate. It's damage to property that has to be valued at between $2,500 and $5,000, which makes that a class 5 felony, which is a maximum penalty of 5 years.
And how many separate fires were lit?
It was kind of done in stages. The way to best describe it is they used a blanket, a towel to try to light a denim jacket, and then ultimately a pillow was thrown into the mix, and then that was thrown on a wheelchair.
What did they light the fire with?
I don't believe that's in the probable cause affidavit, so John Holt would want me to say fire, but I can't. I'm real limited to the probable cause affidavit. Obviously, I would tell you this week, there'll be additional charging related documents filed that again will provide a little more detail, provide a little bit more witnesses. But then most of this really won't come out until the court proceedings begin, and they'll be beginning shortly. Again, I signed the request for arrest warrants this morning.
Would you say this was orchestrated, like well orchestrated and thought out by the prisoners, or would you say that it was, one person fired up and then it was just a domino effect?
It's hard for me to get into the minds of individuals, defendants, inmates. What I would say is, if I would have felt, and the evidence was there that it was well orchestrated, you would have seen an escape charge, and you don't see an escape charge on there. That's what you saw with, other inmate situations. We did not include that charge. It didn't seem to be that type of orchestrated. Some of it might seem circumstance, but there was a level of communication, obviously, to pass instruments on fire across cells and other things, and certainly with respect to the gate and throwing the locker through it, or attempting to throw the metal locker through it. So there was some coordination, cooperation amongst the inmates, but not to the level that I felt escape would be an appropriate charge.
Anything else? Okay. Thank you very much.
Thank you, everyone. I appreciate it.
If you have questions, give me a call.